Many clients contact my office and they would like to appeal the issuance of a final restraining order against them. You have the right to appeal. Your appeal must be filed in Trenton with the Appellate Division within 45 days of the issuance of your order. Now, you have to have grounds to appeal. You can't just say the judge didn't like me, the judge was wrong. We need to have specific grounds to appeal. In addition, you have to keep in mind that the trial will not happen again. Okay, the Appellate Division, the judges in the Appellate Division do not have a new hearing, a new trial where you get to testify and the plaintiff testifies and they relitigate the matter. That is not how an appeal works. An appeal means that we order the transcript of your original trial. We review all of the questions, all of the testimony, all of the judge's rulings, and we try to find errors that were made with the judge's decisions or the evidence, and this would give rise to an appeal. So, if the judge is just going to say that they found the plaintiff, the victim, credible, they believed the plaintiff, and they did not believe the defendant, they believed the defendant was lying, it is going to be very difficult to win an appeal. Many times, the Appellate Division will just rubber stamp the lower court and affirm and say that it was a credibility finding, the judge below observed the witnesses, listened to all the testimony, reviewed all the evidence, and believed the plaintiff and did not believe the defendant. So if that's the case, you should not waste your time or money appealing. On the other hand, if the judge made errors in their rulings or there was not sufficient evidence to show that an act of domestic violence occurred, or there was not sufficient evidence to show that there's a prior history of domestic violence between the parties, or if there is not sufficient evidence to show that the plaintiff is in fear and they need the protection that a restraining order provides, these are all grounds for appeal. If the judge said, yes, you've been harassing her, you sent her 500 text messages, you've been calling her in the middle of the night from all these different numbers, and you're harassing her, but did not detail the second element required under the case law, Silver v. Silver, that there is a fear and the person needs the protection of the court, then that would be grounds for an appeal. So, if you're looking for an experienced attorney to review your transcript, review the case, and see if you have any grounds to appeal and potentially assist you filing an appeal at the Appellate Division within 45 days, contact my office. We can help you.